Hello, my name is Michael Tesoro, and I prepared this presentation entitled Plumbing the Depths of the Courts Port Crown Call. It's a bit of a tongue twister, but what I'll be looking at is the ACCC's case against Port of Botany in relation to these port commitment deeds. And ultimately, I think the case turned on a Crown immunity and derivative Crown immunity issue. But I also think there's a lot of bad law in both the primary decision and the appeal decision. And a lot of red herrings have been thrown out there. That's why I've got that particular image. I think the court got diverted to various issues that really weren't correct. And I do hope the ACCC does appeal this to the High Court, because I think there's a lot of unfortunate law that's been set out in both the primary and appeal decisions. Bit of background about myself. I'm a competition and consumer law, and I've been running my own practice to Tesoro Legal Consulting for the last 15 years, and I help companies in competition and consumer law matters. I'm also an expert consultant to some legal publishers, namely CCH and LexisNexis, on competition and consumer law matters. Prior to that, I worked at ACCC 15 years in a variety of roles, including direct enforcement. And I think the case that I ran that's most relevant to these particular port cases is ACCC on Liquorland, which interestingly was decided by Justice Alsop, as he was then, and the lead barrister for the ACCC was David Yates, who was now a judge, obviously, and he was also one of the judges on the appeal case in the port matter. Now, on the presentation, I'll start with the decision of Justice Jagot back in 2021, and I warn you, it's a really difficult judgment to get through. It's 500 pages long. There's lots and lots of information in it. I don't actually think it's structured very well. It takes 50 pages before you actually get a description of the conduct which is alleged to have been illegal. And for some reason, it starts with purpose and effect and then looks at immunity, Crown immunity issues, which seems to me the wrong way around to do things. Clearly, you want to look at jurisdictional issues first and then the substantive law. So it's very difficult to get through. I think a lot of it is pretty irrelevant information. It's clearly way too long. And then I look at the full federal court appeal decision, which, as I said, was Justice Alsop writing the majority decision. Justice Yates agreed. And Justice Beach actually dissented on the derivative Crown immunity issue, although he agreed with the ultimate outcome, which was to dismiss the ACCC's appeal. And then I look at the Liquorland case, which I think is very relevant to understanding what went wrong in the port case. And it's a very significant case because it does look at how to apply the purpose test under Section 45. And that's clearly what I don't think the courts have done in the port cases. Then I look at the next step. The New South Wales Parliament's passed some legislation to reverse the effects of the port commitment deed. So ultimately, there may not be any anti-competitive impact of those port commitment deeds. And then finally, I finish with some commentary. Now, the background to the conduct is two port commitment deeds with Port of Botany and Port Kembla. And effectively, these port commitment deeds include a compensation provision, which said that if Port Botany and Port Kembla weren't at full capacity and container volumes were diverted to the Port of Newcastle, then the New South Wales government would compensate the operators of both Port Botany and Port Kembla. And there were two thresholds which had to be met. The number of TEUs going through Port Newcastle would have to exceed 30,000 per annum, and further it had to be shown that that new container traffic going through Port of Newcastle had effectively been diverted away from the Port Botany and Port Kembla. So they'd lost business to Newcastle. If those circumstances were met, the New South Wales government would have to compensate the operators of Port Botany and Port Kembla. Now, there was a second port commitment deed, and this was the one that required Newcastle Port to reimburse the government for any money it had to pay to Port Botany or Port Kembla. So if Newcastle set up a container terminal, generated more than 30,000 TEUs of traffic a year, then it would have to reimburse the New South Wales government for any payments which it had made to its competitors in relation to that new traffic. And the way the compensation was to be worked out was to effectively look at the weighted average wharfage charges for TEUs out of Port Botany and Port Kembla, and then multiply that by the container traffic. So just using an example, these are the current wharfage charges of the Port Botany for TEUs, and as you can see, import full containers about 132 excluding GST, export container $90. So you average those two amounts out, say it roughly comes to $111 per container. So if Newcastle was doing 30,000 TEUs, then you times 30,000 by the average wharfage charge, comes to 3.3 million. So that's the amount of compensation at 30,000 TEU that New South Wales government would have to pay Port Botany and Port Kembla, and also the Port of Newcastle would have to pay the New South Wales government. So as you can see, that would not only increase Port of Newcastle's costs significantly in its container operations, effectively paying $100 per TEU in compensation, but it had increased the profitability of Port Botany and Port Kembla, who are getting money for doing nothing. Now, the ACCC made a number of allegations. Effectively, they claimed that the compensation provisions in the two port commitment deeds had the purpose and likely effect of substantially lessening competition. So they alleged under 45.2A2 that the making of the agreements was a contravention, and they also alleged under 45.2B that the two illegal agreements were given effect to. So effectively, probably 4 breaches of the legislation. Now, the issues that arose for the first instance judge were Crown immunity, derivative Crown immunity, likely effect of substantially lessened competition, and purpose of substantially lessened competition. Now, in my view, that's the way those issues should have been dealt with, in that order, but they weren't. They were sort of dealt with in the reverse order, which makes that judgment quite hard to follow. Now, the relevant legislation, 45.2A1, says that a corporation will not make a contract arrangement understanding if it has a provision which has the purpose or effect of lessening competition. So that looks like an objective test, but really the cases have decided that the way to work out what the purpose of a provision is to look at the subjective purpose of the people behind the agreement, primarily the people who introduce the provision into the contract arrangement understanding. So there is a need to look at subjective purpose of individuals and organisations in order to work out what the purpose of the provision is. And then also giving effect to a provision of a contract arrangement understanding which has the purpose and or effect of lessening competition. Now, what's really key here is that representation's been made both by bidders to the New South Wales government and the New South Wales government's financial advisors about the risk of competition arising from different owners of both Port Botany and Port Kembla, and also from competition from Port of Newcastle in relation to containers. So here they're talking about the risk of substitution of a second container terminal in New South Wales before it's economically warranted. And in order to optimise the amount of money that New South Wales government's going to get from selling this asset, it needs to exclude the possibility of competition. It's effectively got to sell a monopoly. And if Port Kembla and Port Botany aren't going to be sold together, they would expect bidders need as much certainty as possible that there wouldn't be the potential for another competing container port starting up in New South Wales, namely in the Port of Newcastle. So here there's a concern being expressed by business people that Newcastle is a competitive threat, maybe not a huge competitive threat, but they see it as something that's not irrelevant, and if it's not dealt with, if effectively potential competition from Port of Newcastle and container traffic is not nipped in the bud, they'll pay substantially less for these government assets. That's a key thing. That's a key finding, which really wasn't given very much weight by the primary judge of the appeal court. Now, I'll start where I think Justice Jagot should have started, which is Crown immunity. And so here she talks about the decision to privatise the ports being a matter of government policy. She says the provisions had nothing to do with those businesses. The compensation provisions served the purpose of ensuring that bidders did not discount their bids on account of the risk that the state policy might change, so that the state could maximise the value it obtained from privatisation. Now, it just seems to me to be the sort of the wrong principle to be looking at here. When you're looking at whether a government entity is carrying on a business, you look at whether they're carrying on a business on a day-to-day basis, operating it, whether it's a one-off. Clearly, an asset privatisation is a one-off. So it seemed to me that Crown immunity really should have been decided primarily, if not exclusively, on the fact that it was a one-off transaction. It's clearly selling an asset is not carrying on a business, it's a one-off sale. But the focus in Jagot's decision is very much on government policy, and then really overcooking it a bit, saying the provisions had nothing to do with those businesses. Well, clearly that's not right. They were seeking to control the level of competition that those businesses would either face or be able to create in the market. They served the purpose of ensuring that bidders did not discount their bids on account of the risk. So the compensation provisions served the purpose of ensuring that bidders obtained a monopoly that didn't face competition. That's really what it's all about. And to just sort of describe it in these particular ways seems to be really divorced from commercial reality. Under derivative Crown immunity, what Jagot decided was that she thought that if the Section 45 liability applied to the owners of Port Botany and Port Kembla, that would effectively divest the Crown, the Minister, the Treasurer, of statutory rights to transfer parts of the state's proprietary rights to the state in these three ports to other parties. So she focused very much on the divestiture of rights, propriety, contractual, other rights that the state held by finding liability under Section 45. Now, the problem here, and I'll discuss this later, is whether that's actually consistent with the Baxter decision by the High Court. I'd suggest it's not consistent with that decision. Now, then the next issue, in my view, is to look at the effect of substantially lossing competition. And here's the main point, really, in terms of effect on competition. Was it rational for a business to set up a container terminal in Newcastle? And really the big argument there, in my view, should have been, is it financially viable? Do the numbers stack up? No private operator of the Port of Newcastle, acting rationally, could have satisfied itself that it could mount, and here's where I think it sort of goes off the rails, could mount a sufficiently strong financial case to invest in setting up a container terminal in Queensland, in Newcastle. That's really the argument. But rather the focus is so much on government policy. So she's saying that no private operator could have mounted a strong case to change government policy to resequence how container terminals were to be developed in New South Wales. That seems to me to be the wrong question, really. Government policy is subject to change. Governments change regularly. Interest groups try to get governments to change policies all the time and have a high degree of success. And so I don't know why it's so based on government policy rather than the simple financial viability of setting up the container terminal. I think would have been much stronger ground if the focus had been on that issue, and I think the judgment would have been 100 pages less had there not been so much focus on government policy. Now, she's concluded that the likelihood of the port commitment deeds having the effect of substantially lessening competition was very low, and for some reason there's this sort of number of expressions included in here, which most of them aren't legal tests. I don't think the fanciful, far-fetched, infinitesimal or trivial tests have ever been established by any court before. The real test is whether there's a real chance or a real possibility that there's going to be a lessening competition. And so really, I think based on the financial viability of a port in Newcastle handling containers, I think her conclusion was right. I think she's overstated it there. And I also think she focuses much too much on government policy, the immutability of government policy. If there's one thing that's not immutable in life, it's government policy. Now, going to the purpose of substantially lessening competition, here she says that the text and context of the compensation provision show that the substantial purpose of the state and New South Wales ports was to ensure the bidders did not discount their bids because of the risk of the establishment of a container terminal at the Port of Newcastle, and for New South Wales ports to ensure that it would retain what it would pay for, the full extent of existing monopoly of port botany in respect of container port service New South Wales. So that's a substantial purpose, but that appears to me to be a substantial purpose of hindering or preventing competition. Effectively, they're saying that we're going to bid a lot of money if we can get a monopoly. If we can't get a monopoly, you're going to bid less. So government, we want you to absolutely guarantee we're getting a monopoly by increasing the costs of a potential competitor, the Port of Newcastle, to a high level, effectively paying compensation equivalent to the wharfage charges that Port of Botany charge per TEU, to make it totally uneconomic to set up a container port in Newcastle. So it's calling an anti-competitive purpose by another name, but that is clearly an anti-competitive purpose. And I just don't understand the way both the primary judge and the appeal court sought to characterise that as something other than an anti-competitive purpose. So she concludes that she did not accept the contention of the ACCC. The purpose of the compensation provisions was to prevent or hinder the development of container port in the Port of Newcastle, which is quite hard to understand how that doesn't prevent or hinder the development of container terminal by adding such a significant cost to them competing, make Port Botany and Port Kembla immune from competition by the threat of actual entry. Again, it seems to be conflating purpose and effect. Here she seems to be saying that the effect of the provisions is not to achieve any of these outcomes, and that may be true, but that's a different question to what the purpose of the provision was, subjectively ascertained. Enable New South Wales ports to act without any constraint from competition. Well, clearly selling a monopoly is the definition of being able to act without constraint from competition, and that's what they wanted to buy, a monopoly position in the market. So then on appeal, the Crown immunity point was looked at by Allsop, and Yates agreed. And again, the focus very much is on the point that I raised before, that selling assets were not in the court of port business. There was a one-off transaction. And I think that's right. I think selling government assets is not in the course of business, and correctly seen, Crown immunity applies. And there it's said again in the next paragraph, it was not that the impugn conduct did not constitute the day-to-day conduct of the relevant business that led her conduct to conclude as she did. Rather, it lacked any connection to the businesses carried on, related as it was to the effectuation of the non-business privatisation decision of a government character and the attempt to effect that maximum value. Now, I don't know why that's added in there, because really the first point is the key point. This was not in the day-to-day conduct of the relevant business, but to focus on effectuation of a non-business privatisation decision of a governmental character. That seems to be red herrings being thrown in there in an attempt to justify the primary justice decision. It's unnecessary. Really, the fact that it was not in the regular course of business is disposes of the issue. Now, derivative count immunity, the view of the majority was that there would be a divestiture of such part of the rights and interests in the relevant legal sense of the Treasurer. Now, this is supporting the view of the primary judgment judge, talking about the purposes plainly included the raising of full value and funds from the proceeds of the authorised transactions for the purposes of the Restart Fund. So here they're talking very much on whether finding the private operators of these two ports liable on the 45 would constitute a divestiture of the rights of the Treasurer. And the big question here is this decision consistent with the Baxter decision? I don't think it is. Now then they move to the purpose of lessening competition. They talk about the fact that we are looking at the subjective purpose of the people behind the terms in order to establish what the purpose of the provision is. And there they're saying that it is not the case that a subjective purpose to ensure bidders do not crimp or qualify their bids or to ensure the retention of the value of that for which the payment was made is necessary to be characterised as subjective purpose of preventing or hindering or constraining competition, because the operation of such provisions could in some circumstances act as a constraint. Now here I think there's a problem, because is the court saying that there was no purpose to lessen competition or that it wasn't of substantial purpose? It seems to me both the primary judge and the appeal court are saying there is no purpose to lessen competition, and I just don't think that's sustainable. Clearly the bidders were complaining about the risk of competition. The government reacted to the risk of competition by entering the poor commitment deeds. That is the purpose. Now if you're saying it wasn't a substantial purpose, maybe that's a different argument. That's not what either court said. And fundamentally, this is the purpose, and it is a substantial purpose. The government is trying to get more money out of private investors by ensuring there's no possible prospect of competition in this market. Now here there's a reference to real world circumstances, which I think is somewhat ironic, because I don't think the way that the courts approach this really reflects real world circumstances. And then they say this in the majority decision: bidding would produce the best price only, and that was highlighted in the initial judgment. The rest is my highlighting. If there was a provision which provided for future compensation should unlikely change of government policy lead to a competing container terminal. In commercial conception, it could be seen as a price adjustment clause or insurance clause should the underlying commercial assumption of the transaction be radically varied. So here they're sort of describing the poor commitment deeds and the compensation provision in a particular way and saying it has a different character to a provision with a purpose of lessening competition. But that is exactly what that clause is seeking to do. It's seeking to reduce potential competition in the future. That's what it's there for. And to describe it in other terms as an insurance clause or something like that is really a red herring, and I think is diverting attention away from what really should be looked at. Then they looked at the effect of competition, and I think this is where the appeal court really did focus on the correct issue. The central and critical finding, the primary judge's rejection of this aspect of the case, was there was no real chance of a container terminal being built in Newcastle and Port Botany while Botany had capacity. Two considerations. Now, firstly, underlying government policy, that's not really, I think, the correct thing to look at. Rather, there was no viable business case to develop a container terminal in Newcastle. That is really the big issue, because that's established by the facts. A lot of people had looked at the possibility of setting up a container port in Newcastle and dismissed it. The government policy issue is not something you should be trying to base these types of decisions on, given that we are fully aware of how regularly government policy changes. Now, Beach, he dissented on the derivative Crown immunity issue, and here I think he has really followed the approach taken by the High Court in Baxter. Now, he says the appropriate starting point in trying to determine whether there is derivative Crown immunity is not to start with the relevant state legislation, the PAAT Act, but rather start with the Competition and Consumer Act and look at the relevant provisions, Section 2, 2B1, 45, and crucially 51, which provides for exemptions from the Competition and Consumer Act for the Crown. How are they intended to fit together? And really, it's only once you start at that point that you can see the extent to which 45 has been modified. So if a state wishes to exempt anti-competitive behaviour from the CCA, it can do so under 51.1. It's set out what needs to be done. And there he says he agrees with the ACCC that it is not consonant with the intention of the Commonwealth Parliament to hold that New South Wales Port Consortium did not contravene Section 45 of the CCA because its conduct was required by the Treasurer under PAAT Act, which did not relevantly meet the requirements stipulated in Section 51. Now, if we look at 51, what are the requirements? In deciding whether a person has contravened this part, the following must be disregarded. Anything specified in and specifically authorised by an Act or regulations made under the Act. The two key words there are specified and specifically. And then you've got under 51(1)(b), anything done in a state, if the thing is specified in and specifically authorised by an Act passed by Parliament or regulation. So what they're saying here is there's a facility under Section 51 of the CCA to exclude conduct from the Competition and Consumer Act. That's the way that government should be seeking to operate. And if they're not doing that, then it is not appropriate to be finding this Crown immunity based on these older concepts of whether it's impinging on a state right or state's proprietary or contractual right. Clearly, the New South Wales government could have done this. It didn't do this. Therefore, we shouldn't be trying to find Crown immunity. You should not be ignoring Section 51 of the CCA. Now, he goes on to say that, the CCA should be construed by reference to all the provisions to determine whether it excludes the operation of Crown immunity, as Section 2B cannot be properly construed in isolation from the balance of CCA. So 2B is talking about carrying on a business. So how can you look at 2B, carrying on a business, and not look at 51, which sets out the mechanism for excluding state actions from the jurisdiction of the Competition and Consumer Act? So he concludes that the fact that the contracts were of high significance to the state policy and economic objectives was a distraction, I'd probably say a red herring. They're irrelevant to the legal question of the interpretation of the CCA. You can't distinguish Baxter on the fact that the contracts were made for sale of assets and Baxter was for the sale of products. It's got absolutely no bearing on the legal test. And when you look at Baxter, and that's a really long quote, I'm sorry about that, but this is the principle from Baxter. Underlying the argument is the idea the Act operated so as not to enact any law that would circumscribe the freedom of the Crown and right of state or territory to make any kind of contract it wished, and furthermore that the Act preserved the Crown's freedom in that respect, by providing that corporations dealing or negotiating with the Crown should be free to propose and make any kind of contract unfettered by any constraint of the Act. That's the interpretation that the primary judge and the appeal court has taken. These ideas cannot be supported by reference to any established principle of statutory construction, and they are impossible to reconcile with the purpose and subject matter of the Competition and Consumer Act. It is one thing to read the Competition and Consumer Act so as not to divest the Crown of legal rights. It is another thing altogether to read the Act as giving an executive government, the New South Wales government, as distinct from a parliament acting under Section 51(1), including all its services and agents, a freedom not enjoyed by the government itself in carrying on business from any impact of the laws enacted for the promotion of competition and fair trading in the public interest. So this reliance on the rights and proprietary rights, contractual rights of the Crown and the state, and being providing derivative Crown immunity to third parties doesn't work. You really have to look at the Competition and Consumer Act, the relevant provisions there, and rely on that framework to decide whether there is derivative Crown immunity. So I agree with Beach. I just don't think that Jagot or the majority has followed Baxter appropriately. And the interesting thing here is that in the lower courts on the Baxter decision, it was Allsop's decision that got overturned on Crown immunity. And in the High Court in Baxter, it was Justice Yates who was representing Baxter and put the contrary view on Crown immunity and derivative Crown immunity. So that's not entirely relevant here, I think. So there was one thing that Beach was particularly critical of, and this was a comment by Jagot 402, where she says that the scheme of the New South Wales legislation ensured the Treasurer to do whatever was required for the purpose of an authorised transaction. On that basis, the legislative intention of the New South Wales Parliament enacting the PAT Act must be discerned. The New South Wales Parliament intended that the statutory rights vested in the Treasurer of the PAT Act included the Treasurer for the purposes of an authorised transaction requiring a third party to breach the Competition and Consumer Act. Now that's a pretty amazing statement. There's no way you can discern an intention from the PAAT Act to require a third party to breach Section 45 of the Competition and Consumer Act. So he was critical of that statement. That was a pretty remarkable statement for Jagot to make in her primary judgment. Just moving to Liquorland, and I said that earlier, that this is a case decided by Justice Alsop and the team we had running it. I had David Yates, senior counsel, running the arguments about purpose. The first thing was here that there was an argument by Woolworths, more or less arguing for a counterfactual analysis in relation to purpose, and that would require looking at maybe the effect of the conduct. And the clear thing Justice Alsop concluded is at the end there, to require a case based only on purpose to contain a real effect on competition is to insert into the statute an element not provided for in the Parliament declined to do so. So when you're looking at purpose, you can't sort of say, well, the purpose couldn't have been the purpose because the effect was not likely to occur. That's conflating purpose and effect, and I think that's exactly what Jagot and the appeal court have done in this case. They conflated purpose and effect. They said the New South Wales government can't have the purpose of lessening competition because competition could never occur. But that isn't the test. Clearly, the bidders for the business were concerned about a very small risk of competition, and the New South Wales government purpose was, in entering the poor commitment deeds, was to snuff out that small possibility, to eliminate that small possibility of competition. Now, if the argument had been it wasn't going to substantially lessen competition, that might have been an argument, but that wasn't the basis of the decision of the court. The basis of the decision of the court was that there was no substantial purpose of substantially lessening competition, and that is just not consistent with the real world, and it's quite contrary to what was happening, what the bidders were saying, why the government made the changes. So this seems to be contrary to the way that the issue of purpose was approached in the Port case. Also, looking at what was going on, and in this particular case with Liquorland, there were very small players who were seeking to set up a very small business to compete in the provision of liquor, and Coles and Woolworths went to great trouble to stop that from occurring. And what Alsop concluded there, if a firm has a purpose to impede or prevent entry of a new competitor into a market, lest that new entrant conduct itself competitively to wrest business from the incumbent and so damage the business, that purpose involves the process of competition. It involves preventing entry into a market and preventing a state of affairs of lost sales through additional competitive activity. So these deeds were aimed at stopping small companies entering the market that may have presented some competition down the road. Here, the purpose of this provision was to ensure that the Port of Newcastle could never economically viably operate a container terminal. And then the second paragraph there, the question is, what was the purpose of the provision? In this case, what was the subjective purpose of Woolworths as to the provision? Was it relevantly to prevent, restrict or limit the supply of acquisition of goods to or from particular persons or classes of persons? If the restriction is to operate through a party not yet able to supply, that does not gainsay the purpose, which is one which is to operate in the future. So even though there was no immediate competitive threat from these small operators, really what you're trying to do is nip competition in the bud to reduce the ability of that new entrant to compete into the future, which is just exactly what was sought to be done with the port commitment deeds and the Port of Newcastle. Now here, this is, I think, key issue. A substantial purpose of the ejections in the Liquorland case and the provisions was to prevent the licence being or becoming the platform or vehicle for a market entrant without restriction on its licence. So it was to prevent this valuable asset coming into the market, which by itself had very little competitive impact, but could be used as a springboard to greater competition in the future. And as he says there, it was a purpose to ensure as far as was possible by the provisions that the licence to be granted could not in the future be available as a scarce and potent item to be used by an entrant to the business of selling takeaway liquor in the local area where Woolworths had or would shortly have a liquor outlet. So it's nipping competitive threats in the bud when they look like they can't be a threat. And this is really all going back to the idea of killer acquisitions, killing off competitors before they've risen to a scale that can threaten incumbents. And the best people to spot those potential big competitors in the future are other players in the market. I think we all agree that Google and Apple and Facebook or Meta are best placed to identify the potential threats coming into the market that are going to damage their profits in the future that they need to buy up. And here again, the best people to determine the competitive threat posed by the Newcastle port were the people vying to buy those monopoly assets. They could see there was a risk and they wanted that nipped in the bud. And they succeeded in nipping that in the bud. So just, I guess, the next step. In November 22, the New South Wales Parliament passed some legislation which effectively established this process to extinguish the effect of the port commitment deed. So extinguish the liability of the Port of Newcastle to reimburse the state for compensation paid to the operators of Port Botany and Port Kembla. So this is really important because the financial impost created by that port commitment deed on the Port of Newcastle is being removed, and that means that clearly the financial viability of exploring that issue has been improved somewhat. Clearly there's still a lot of things to overcome to make that a viable competitive alternative. Now, was the decision wrong or right? I think it was wrong. I think Crown immunity existed, and I think that was correctly decided. There was no ongoing business of, running ports that was involved with this particular conduct. Rather, it was a one-off activity of selling a port, and I think that's pretty well established law. The prospect of one-off sales is not carrying on a business. However, I think the derivative Crown immunity point was wrong. I think Beach's approach to that issue is correct, and I think it's a return to the pre-Baxter law, and it just seems to me that there's been an attempt to sort of distinguish Baxter, but really the same arguments for running Baxter, and that hasn't been taken into account. So I think it's wrong on derivative Crown immunity, and if it's wrong on derivative Crown immunity, that means that the Port Botany is liable on the 45. Clearly, the derivative Crown immunity finding is much too broad. It gives state governments much too much latitude to exempt conduct, which it is not specifically identified in legislation. Now, I think the effect case looks right. I think the viability of running this, setting up this port is very shaky. That may change in the future for a variety of reasons, but at the moment, the business case can't be made out. So I don't think there's an effect case. But I think there is a purpose case. Clearly, the purpose of these provisions was to meet the needs of buyers of monopoly assets who wanted to snuff out even the smallest possibility of competition in the market. That was what it was all about. And I think in terms of dismissing the purpose case, I think both Jagot and the appeal court conflated purpose and effect. They said, well, the subjective purpose couldn't have been to lessen competition because there's no way competition was going to be effectively reduced. But that is not the test. You have to look at what the parties were seeking to achieve, and they were seeking to achieve a lessening of competition. They were seeking to reduce and prevent competition from occurring. An argument may have been that the reduction in competition was so small that it wouldn't have been a substantialist in competition, but that's not the basis on which the judge concluded it. I think the approach taken both by Jagot and the appeal court is highly strained, which is sort of ironic because I think they accuse ACCC's interpretation of being strained, but I think it's the other way around. The question, does it matter? Well, it doesn't probably matter in relation to Newcastle anymore because this extinguishment legislation will mean that they no longer have this additional high cost impost on their operation of a container terminal. But I think it does matter because I think the decision is inconsistent with Baxter. It creates a very broad derivative Crown immunity argument which needs to be addressed. I also think the law on purpose is just very messy. I think it's incorrect, and I think that needs to be cleared up. The thing I don't understand is why courts don't just start with the jurisdictional issue about Crown immunity, derivative Crown immunity, make a decision on that, and then not get into all the purpose and effect stuff, because there's no real necessity to do that, particularly on the purpose side. The purpose arguments, both by the primary judge and the appeal court, just seem really not reflecting real world circumstances. Business people care about competitive risks. They raise it with government in writing. The government reacts to that competitive concern by entering into very elaborate agreements to stymie potential competition. That all adds up to a substantial purpose of substantially less competition in a market. And for the judges to try and characterise that any other way suggests to me that they're very, very much out of touch in this particular case. So that's all I had. I guess I got a bit fired up about this one because it's just frustrating. I didn't read the primary decision by Jagot, or didn't do a presentation on it initially because I was so sure it was wrong. And I was very disappointed when the appeal petition came out and it affirmed all the points, particularly the purpose point. I just don't see how that is in any way consistent with the approach taken by the court in the Liquorland case, which was written by Alsop and which was presented by David Yates when he was a barrister. So that was disappointing. And I think the Crown immunity point is clearly, derivative Crown immunity point is clearly wrong. Beach is correct. And now we've got this inconsistency in decisions which really shouldn't be allowed to persist. So I do hope the ACCC appeals this case, although I have the suspicion they may not. But that'd be unfortunate. So that's all I had. If you have any questions about this presentation, which is a bit overly long, apologies for that. But I think we worked out all the red herrings and we plumbed the depths of this decision. And I think hopefully that clarifies the issue. So if you have any questions, feel free to send me an email or give me a call. Bye-bye.